Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court now sitting.
Thank you. Please be seated. Good morning. Welcome to the Supreme Court of Kansas. We have carefully read counsel's briefs on the cases for this morning's docket, and we look forward to enlightening comments from you and oral arguments. At this time, Ms. Green, as clerk of the appellate courts, I'd ask you to do the honors of calling this morning's docket. I now call the first case on this morning's docket. That is case number 102938, Daniel L. Hemphill v. J.F. Shore, Trustee of the Shore Family Trust, Appellee.
May it please the Court, Counsel, Chief Justice, I would request that 3 minutes be reserved for rebuttal time.
3 minutes is granted.
This is essentially a breach of trust case and a constructive fraud case. There are two other claims that were in the initial petition, that of conversion and breach of fiduciary duty. We deal with those cases in our appellate briefs, but we're not going to be arguing them here this morning. I would reserve the right to contend that those cases are subject to any equitable relief that the court would grant, but that's not the purpose of the appeal argument this morning. The case was brought to the Sedgwick County District Court upon defendant's motion to dismiss. The argument of the defendant on the motion to dismiss was that under applicable statutes of limitation and statutes of repose, the plaintiff's case, which brought breach of trust case and constructive fraud claim, failed to satisfy either the statute of limitations or the statute of repose, and under any set of circumstances would fail on those bases. A very brief factual background. Essentially, there was a trust created with some farm ground in it in western Kansas. The trust was created in 1984. In 1992, one of the co-trustees were brother and sister. One of the co-trustees passed away in 1994 and 1995. The principal of the trust was distributed out after the trust was created, but prior to the death of the co-trustee who was also a beneficiary had a son who also qualified as a beneficiary under the trust.
Who was to step into his mother Susan's share of the trust?
Excuse me, Justice?
The son was to step into his mother Susan's share of the trust.
He was.
But
That's
not
correct.
not until his uncle had died, right?
He was an income beneficiary.
Income beneficiary, but not the principal.
But his right to receive any of the principal
did not
correct.
ripen until the death of the co-trustee. I want to talk about pleading.
Yes, Justice.
Would you show me in your second amended petition where you pled the facts necessary for constructive fraud or breach of trust?
The breach of trust, constructive fraud, and breach of trust, correct, Justice? Okay.
Yes, those two causes of action, the facts necessary to support them.
The breach of trust claim, essentially, the breach of trust claim is based on our contention that you have a self-dealing transaction and a failure to inform the beneficiaries of the self-dealing transaction. Self-dealing transaction essentially liquidated the farm ground, which was the initial principal of the trust, and then distributed it all to the defendant for his own personal purposes.
Now, that would have been permissible, would it not, under the language of the trust, as long as it was for the health, education, support, or maintenance of the co-trustee defendant, correct?
I believe that's correct, Justice.
Okay. And so where is the fact that tells us that that was not the purpose of that liquidation?
I don't. There is no fact pled that tells us that that was not the purpose of the liquidation.
Okay, and do you think that's not your responsibility when you plead a breach of trust or a constructive fraud based on that behavior?
I believe that there is a responsibility to plead that the trustee violated one of his obligations of the trust, which is to notify the beneficiaries of the trust that he's doing something with the entire sum of the trust principal.
So are you saying now that those two causes of action are based entirely upon his failure to notify?
They're not. The breach of trust hinges entirely upon his failure to notify.
Okay. And then the constructive fraud, where do you plead what's additionally needed for that?
The constructive fraud case, essentially, the background facts indicate that you have a trust that's created, and then after the trust is created in 1984, after the trust is created, you have a son that's born to one of the trustees and beneficiaries, and then, a few years after that, essentially, when the child is about 5 years old, his mother dies, and then within a couple of years after that, everything is distributed out.
Right.
And
what was fraudulent about that? I mean, you said that nowhere do you plead that was not for the health, education, maintenance, or support of the co-trustee at that point. I mean, do you have facts anywhere in here that tell me that was for something outside those purposes that are permissible under the trust language?
I don't have any facts that indicate that the distribution was for impermissible purposes under the language of the trust. My facts indicate that that there was a failure of the trustee to comply with his obligations to notify.
So is failure to notify, again, the only basis for the constructive fraud claim?
It's not the only basis, but is one of the primary.
What other basis do you have?
The other basis is that he has another beneficiary, and he has an equitable duty to notify that other beneficiary that he's.
So that's again based on failure to notify, though. It's not that he spent the money or used the money for something other than health, education, support, or maintenance.
That's correct, Justice. There's no facts that are indicated that he spent or used the money for anything other than his personal purposes.
But he had a fiduciary duty to also take care of the health, education, support, and maintenance of your client. When Susan died, your client stepped into Susan's, and the trust didn't say only for Jay's health, education, support, and maintenance, but for everyone. Is that what you're arguing?
That's correct.
And so your client is arguing that there was fraud because his needs were not met as directed by the settlors?
That's correct, Justice.
I'm going to change gears on you, was the value of this property included in Susan's estate for federal estate and Kansas inheritance tax purposes?
I don't know the answer to that question, Justice.
Well, are you aware that health, education, support, and maintenance are contained in Internal Revenue Code 2041, specifically B1A, that talks about the exception to general power of appointment?
I'm familiar that there's a distinction in the Internal Revenue Code between what's called a discretionary trust and what's called a support trust.
Well, we're talking about ascertainable standards here. And that if there was unfettered discretion to appoint this for Jay, then there was unfettered discretion to appoint it for Susan. They could have done the same thing, correct?
That's correct.
Because they weren't treated differently. And if there was unfettered discretion to appoint it for Susan, then it's tantamount to being her property, and it should have been in her estate. Was that issue brought up at the trial court level?
That issue was not raised at the trial court level.
Back to the duty to
Excuse me. Go ahead.
Back to the duty to notify. Setting aside any issues of discovery, did that duty to notify accrue in 1995?
I believe that he had a duty to notify on an annual basis pursuant to the language of the trust.
So you're saying your contention is that even though the assets had been distributed in 1995, that he had a duty to report after that point?
The question would be whether there was or was not a dissolution of the trust. If the trust is gone, then obviously he has no other duty to notify. If the trust is still in existence, then he does.
And is there a question of fact on that as to whether or not the trust was dissolved or remained?
I believe there is a question of fact, and I raised that in argument at the district court level.
And what's your basis for saying there's a question of fact on that?
Well, the only basis for saying that the trust no longer exists is because the trustee, who did not notify his co-beneficiary, said that the trustee no longer existed. Whether or not, in fact, as a matter of law, the trustee went away would be a question of law, and then based on questions of fact that needed to be answered, maybe in a deposition, maybe in factual discovery.
I have another question, Mr. Kite.
Yes.
A moment ago, my colleague, Justice Johnson, was asking you about your argument, and he suggested that your client is arguing that his needs were not met as directed by the settlers. You agree with that?
Correct, Justice.
That that's your argument in addition to the failure to notify for the constructive fraud claim?
Correct.
Can you show me in your petition where you pled that his needs were not met as directed by the settlers?
I don't believe that I pled that specific fact, Justice.
Okay, thank you.
The Court of Appeals, again, considered the matters that were considered by the district court, and essentially both the district court and the Court of Appeals addressed specificity of pleading. The case, as initially presented by the defendant, was a statute of limitations case, but the district court and the Court of Appeals saw this as a specificity of pleading case. Essentially, they said there were not specific facts present to allow for a constructive fraud claim or a breach of trust claim. Because those specific facts were not present, the case should be dismissed. They said that the lack of specificity meant that there's no fraud claim. Because there's no fraud claim, the statute is not told. I would leave the court with 3 points. First of all, there's a breach of trust claim. We contend, again, that case rises and falls on the Jennings case, which is cited in my brief. That the discretion in the trust is not, in fact, unfettered discretion, that there are standards that needed to be complied with.
What are those standards that need to be complied with in order for Jay to distribute?
The standards were listed in the trust as support,
Right, I understand that, but the district court found that Jay had the unfettered discretion to distribute to himself, as he did in this case.
They essentially found that he had the authority to interpret what was support, maintenance.
And did he have a duty then to disclose what that support duty, the support, maintenance, and education to someone?
I believe that's the crux of the lawsuit, that he had a duty to disclose that he was in fact complying with the terms of the trust.
What's your second point?
The discretion was my second point. The third point was that I believe that sufficient facts were alleged to make a constructive trust claim.
See, the council's out of time. Do we have any further questions?
I do, excuse me. Chief, I have one question. To make a constructive trust claim or constructive?
Sorry, constructive fraud claim.
Okay,
there was
because
a
constructive trust is just a
That's
remedy.
a remedy.
Yeah, okay. You have it set out as a separate cause of action in your second amended petition, but it's really not a separate cause of action, is it?
It truly is a remedy that would be imposed if
I thought we'd
constructive
agree on
fraud
that.
is
Thank you.
Any further questions? Thank you, counsel.
Good morning. May it please the court, Jeffrey L. Carmichael, appearing on behalf of the appellee, Jay Shore.
Do you know if the value of the property was included in Susan's decedent's estate for tax purposes?
I do not, Your Honor. I have not.
Would you agree that if she had unfettered discretion to appoint it to herself, that would be her property?
You know, Your Honor, one of the things I did in law school was keep away from tax classes.
Well, I think it's pretty important that you get into tax purposes when you're looking at estate planning trust, and that the use of health, education, support, or maintenance is not fortuitous, since if you look at 2041 of the Internal Revenue Code, it has those very exact words. And you do that so that you can provide a life income that's not taxable, but have a safety net to evade the principle, which was done here. It's very clear to me what was intended here, because there are hundreds, if not thousands, of trusts out there that same way, and they utilize ascertainable standards. And if that's true, how can we accept your argument and the district court's finding that Jay could give it to himself to go to Vegas or whatever? No standards whatsoever.
I believe, in answer to your first part of that response, Your Honor, if I had a tax question, I'd walk down the hall and talk to Bob Anderson, who's my partner in CPA, or Shannon Braun, who is a tax attorney, and ask those questions. And by the way, Shannon's the one who wrote the brief in this particular case and did an excellent job of it. With regard to the question you're raising, though, is the issue is, what did my client do wrong? And he's being sued. If there's some provision of the tax code that Susan could have taken advantage of and did not, I don't see how that in any way reflects poorly on my client, that there'd be a cause of action.
We're talking about the intent of the settlors. We don't care about your client. Your client's intent is not involved in the interpretation of the trust, is it? Jay, your client's parents drafted this.
Absolutely
had
true.
It drafted.
Absolutely true.
And Article 7, subsection M, they told your client what they were doing. They said that the primary purpose of this family trust is to provide for the specified needs of Jay and Susan, and then specified needs of their children, and then specified needs of their children's issue. Now, specified needs, the only specification is health, education, support, and maintenance. That's all that's specified. So why aren't those needs, specified needs, a constraint on the distribution of assets?
Because I don't think those are the only restraints, Your Honor. If you take a look at the trust itself, it also says at any time if they want to distribute the income for purposes of a career or to buy a home, those were acceptable means or acceptable reasons to distribute the principal to themselves. So health, education, and welfare are not the only criteria. But I would go a little bit further than that, too, and point out that it's very clear from the intent of the grantors of this trust that they wanted no court involvement in the administration or running of this trust. They very clearly set that out in one of the provisions. They want to make sure that they're waiving the requirements of reporting. They want to make sure that there is no court involvement in the manner in which this court...
That doesn't do away with your client's fiduciary duty as a trustee. They didn't waive his fiduciary duty. They waived oversight by the court.
True.
But that doesn't mean that if he violates the terms of the trust that you can't get the courts involved.
I think, Your Honor, that what you're talking about in terms of the responsive or the discretion given, the discretion given by the grantors was extremely broad, to be liberally construed to absolute discretion for Susan.
If Jay is a multimillionaire, under your interpretation of this, he can go ahead and take the trust because it just allows him discretion to take it. He doesn't have to explain to anyone. He just has that capacity so he can do it.
Yep, because his parents gave him that right. His parents put the trust together.
What's the purpose of the trust?
The purpose of the trust was to give I assume, a benefit to the children of the parents of Jay and Susan. and potentially their grandchildren. But keep in mind, the grandchildren, the trust itself says that the trust may not even be there when the grandkids have a right to take it, because it may have already been distributed, and that's in the trust language.
But how do you address the condition precedent? You want to point to the place that they can distribute it to Jay or Susan to the extent they deem necessary to provide for their benefit. But when we look at a sentence, don't we look at the entire sentence? And the condition precedent to doing that says, in the event the income of the Shore Family Trust is insufficient in the trustee's sole discretion to provide for the health, education, support, or maintenance.
Yeah,
What was the purpose of that phrase if it's just unfettered discretion? Why do we need to make a determination of sufficiency of the income if it doesn't matter?
You don't have to. It was the discretion of the trustees, not the discretion of the court, in making that determination. The grantors of the trust very clearly said that in the sole discretion of the trustees, if they thought it was insufficient, they had a right to invade.
But the point is, they still need to make that finding. There has to be a finding by the trustee that the income's insufficient to provide for the health, education, support, or maintenance of Jay or Susan, or Susan. That's what this says, right?
I think what it says is that they have the discretion to make these determinations, free from court involvement. And I think that's kind of where I think we may be. I mean, who are you saying they need to report to? Are you saying they need to report to the court? I don't think that's accurate.
I think they need to report to the other beneficiaries. Because at the time after Susan died, Jay was no more entitled to have the income or the principal than Susan's son. They were both trustees.
I disagree, Your Honor. The trust very clearly says that the children have no right to principal until Jay dies. I believe that there's a trust established for the children once he passes away, if there's anything left.
Well, I guess I'm confused on your analysis of the term discretion. There's no question that they had discretion, but I think what Justice Johnson's trying to say is that discretion was limited. They had to, in order to invade the principal, there had to be a showing that it was insufficient to provide for the health, education, support, or maintenance of Jay and Susan. So it's not that they have sole discretion, is it? It's that they have the discretion to make the decision only if these conditions are met.
But I think the problem...
And I think you're suggesting that those conditions, if they're not met, that's also within the sole discretion, that they can ignore those conditions.
No. I think the difference is you're saying, well, there needs to be some criteria out there that we can measure this against. And I think what the grantors of the trust were saying, no, we're giving this right to the trustees, our children, whom we trust, to make these determinations. We don't want to be in a position where somebody gets to second guess their decisions. This is a discretionary trust, discretion given to the trustees by their parents.
So if the trustee says, I don't need to show that it was insufficient to provide for the health, education, support, or maintenance of me or my sister's son, that's in his discretion to say, I don't need to show that despite that inclusion in the trust language?
No, I think once he makes the determination that the need arises, he's made that discretionary determination. He doesn't have to prove it to anybody else.
So you're saying
he doesn't have to come into this court and say, here's my basis, here's my decision, this is the criteria that I utilized. That's exactly what the grantors of this trust were trying to get away from.
So he did have to make that determination.
On his own, yes.
And there's no allegation he failed to make it, is there?
I'm sorry?
There's no allegation that he failed to make that, is there?
There is not. Actually, there's no allegation of any wrongdoing by Jay Shore in connection with this trust.
Well, there's an allegation he violated it, but that's a legal conclusion rather than a fact, right?
Correct. I mean, there's no facts that say this is what Jay did wrong. Unlike the Jennings case where there was stock transferred in direct violation of a term of the trust, there's no allegation here that Jay did anything in violation of the terms of the trust agreement.
Do you think this was a discretionary termination?
Yeah, I believe it was.
Why wouldn't the provisions of Article 7, subsection I, dealing with discretionary termination have applied?
I'm sorry, I'm looking right now at the trust agreement. You said Article 7?
It speaks about a discretionary termination and says that one share is to be distributed to each beneficiary surviving.
You're looking at subsection 7I?
Right.
That says in their discretion, if the amount of money isn't sufficient, they have the discretion to dissolve the trust.
And how do we know that isn't what happened? You're saying Jay doesn't have to say. I mean, I don't even know if the reason it was terminated was because he took the money as part of his income distribution. How do we know that? You're saying we don't even have to know why he did it, but if he did it because, I'm tired of messing with this, it's costing me more to mess with it than it's worth, then under that section he should have given a share to the nephew.
I don't believe so, Your Honor. I think with regard to and again, you're dealing with absolute discretion, and again, that's what it says. That's the term, that's the exact language that's used here in I.
To terminate, absolute discretion to terminate.
Correct.
But there's no discretion on who to give it to. It says every beneficiary that's living then gets one share.
I understand, Your Honor. I believe at that time Susan had already passed away. I don't recall whether at that juncture Mr. Hemphill would have been entitled to an income portion, but I believe under the facts of this case, as alleged in the petition, the sale of the property was for more than $75,000 or $75,000. And a determination made by Jay at that point to distribute those funds, it would seem unlikely that it was under this provision that is the way in which the trust was dissolved, given the amount of money involved, and it's alleged in the petition. But regardless, the discretion is given to the trustee to make that determination. In our opinion, this is a statute of limitations issue. This occurred 14 years or more before the filing of the petition. We run through every analysis available, whether it be disability or whether it be the 10-year statute of repose or the 2-year statute of limitations or the 5-year statute of limitations. There is no way you can get to a position either pre or post Uniform Trust Code that there's any cause of action left alive.
Unless there's a well-pled fraud claim, right?
Unless there's a well-pled fraud claim, that's true. But
you don't dispute that a well-pled fraud claim would continue?
It could, if there are sufficient facts alleged.
Yeah, I'm just saying if it were pled adequately.
Correct.
You don't dispute that?
No.
Okay. Just getting the parameters in mind.
And there seems to be some issue about whether under constructive fraud or constructive fraud, whether you have to, that's in the well-pled fraud provision. It seems inconsistent on one hand to say, I'm going to take advantage of the fraud provision under 6513B or 6513A2, but I don't have to plead it. That seems inconsistent to me. If you're taking advantage of the provision allowing you to extend the statute of limitations because of fraud, then go ahead and plead it. And there's nothing wrong with it. If you take a look at the constructive fraud cases, they say a relationship and then breach of that trust or that relationship. The second element is plead it. Plead some facts that show that there's something done improper. So I think.
So you're saying that the elements of a constructive fraud would be a fiduciary relationship and a breach of that duty.
Correct. I believe that's what the case law says, Your Honor. And all I'm saying is, if you want to try to use that, then plead it. Show where in the pleadings, factually, that there's some breach of that relationship, like in Jennings, the sale of the stock.
Let me ask you this. You were saying there was no obligation to distribute anything to the nephew until Jay died?
I'm doing that from memory, Your Honor. I don't have the entire trust.
If that's the case, how was the 5-year-old child to know that he needs to bring a cause of action against his uncle until the uncle died? Until the uncle dies, he doesn't, if under your theory that he's not entitled to anything, how would he have notice that the uncle hadn't preserved his share of the trust as a trustee is supposed to do? How would he know that?
I would suggest, Your Honor, that the answer to that would be under the Uniform Trust Code. The cause of action goes from the time of the termination of the trust, and the trust was clearly terminated in 1995.
But how does he know that? How does a beneficiary that's not being given any income and under your theory is not entitled to have any complete distribution until the death of the trustee, how is that person to know to bring an action if they don't even know the trust is terminated and have no reason to know until it's time for them to get their share?
I think, Your Honor, that there was, I think the answer to the question is the trust terminated in 1995, and more than 14 years had passed.
And the child was 7 years old.
Correct. And he then
you're
turned
saying
18.
that the uncle's saying, I took all the money, that if I'd have kept it, the child would have gotten half of it, but I took all the money, and my answer to that today is the 7-year-old didn't sue me.
Well, I believe, Your Honor, that there are several scenarios under which he would have a right to turn 18, within 2 years of turning 18, to bring a cause of action if he thought one would exist, a 10-year statute of repose, an 8-year statute of repose on the age issue. All of those run well before this cause of action was initiated.
You'd reserve 3 minutes for rebuttal.
May it please the Court, a couple of final points. I think an issue that's very important to this case is the fact that a trustee, particularly in this situation, has not only the powers that are granted to him by statute and in the trust document, but if he chooses not to notify the beneficiaries, he certainly has the power to keep a secret. In this case, all we're asking the court to do...
I'm sorry, I didn't hear you, Mr. Kite. He certainly has the power to
keep a secret if he
you.
chooses not to send reports. All we're asking the court to do, and you'll notice that Mr. Shore's not coming forward with evidence that he, in fact, sent any reports, and he's not coming forward or attempting to come forward with any evidence that as to what he did with the principal of the trust.
Does he only have a duty to report to the income beneficiaries?
I believe he has a duty to provide annual reports to all beneficiaries of the trust.
All potential beneficiaries?
Yes.
Do you agree that your client was not an income beneficiary at the time of his mother's death?
I believe he was an income beneficiary at the time of his mother's death. Those are my closing comments. Jennings, just a comment on the Jennings case. That case was decided after a full round of full round of discovery upon summary judgment. It was not a pleadings case. I think that may be relevant to the case at hand. Unless there are any questions, plaintiff will rest on his brief.
I have one quick question.
Yes.
We don't have anywhere in the record the date upon which your client learned that he might have a cause of action, right?
No, and it wasn't pled.
Okay, thanks. I just wanted to confirm that that was your understanding as well. Thank you.
Do we have any further questions of counsel? I see none. Thank you, counsel. Thank you both for your arguments this morning. The court will take this matter under advisement.